Once again, good evening, everybody. Hope you're all very, very well this evening. Thank you all for joining us this evening for our 101 of HR for physiotherapists. These webinars are designed to get into the nuts and bolts of managing employees in specific industries. So hopefully there'll be some information in here that you'll find useful this evening. Now, before we start, I would just like to take a moment to acknowledge the traditional custodians of the various lands that we meet on and work on today, and pay respects to our elders past, present and emerging. We extend that respect to Aboriginal and Torres Strait Islander people here today. Now, just by way of a very quick introduction, for those who have not met any of us yet or have not worked with any of us, this is the team at Strawberry Seed. We are a company that is 11 years old this year, and we essentially help and work with multiple small and medium businesses across the country, hopefully helping them succeed and coach them through a variety of HR issues. Just a few housekeeping items before we get started. We will have a questions section at the end. If you would like to ask any questions along the way, please feel free. Please use the chat function or the Q&A, preferably the Q&A if you can, and I'll come to them all at the end. I do also want to let you know that obviously the information that we talk about and discuss today is very general in nature. So it's based on the knowledge we've gained over many years of working with clients in the industry, but we would always recommend that you would seek specific advice from a trusted professional or Fair Work about any individual situations, because that might have a change of the outcome of the type of advice. So please bear that in mind. And like I say, you're more than welcome to get in touch with Strawberry Seed at any time. Okay, so what we're going to cover tonight is governance, what actually governs our employment relationships, employment types and how to classify under the relevant awards. We'll then look at rates of pay and remuneration. We might even touch on things like overtime, allowances, remuneration. We will also talk about documentation, which is a golden rule of thumb that we probably say day in, day out, is document everything. And we'll talk about why that's so important towards the end. So moving through, let's start at the beginning. How is the employment relationship governed? Now, there are a few different steps, a few different entities, if you like. So you have at the top there in red, you have the Fair Work Act and you have the NES, which is the National Employment Standards. So the NES lays out the minimum entitlements for all employees in Australia. It covers things like the national minimum wage, maximum weekly hours, notice of termination, things like redundancy pay, etc. So that is governed by everything. That all employment is governed by the National Employment Standards. The next level is then an industrial agreement or an industrial instrument. So this would encompass things like an enterprise bargaining agreement or an EA or an EBA or a relevant award. Now, there's something like 121 awards in the Fair Work legislation, so there's a few to choose from, and it can be very hard to try and work out what applies to business and individuals. Finally, then you will have your employment relationship governed by potentially an employment contract or an employment agreement. So it's important to know that those three things will govern an employment relationship. So your first port of call will be, is there an employment contract? And what does that stipulate for whatever issue it is you're trying to resolve? If you don't have a contract or it is silent on the element that you wanted to investigate, you would fall back to the award or the enterprise agreement. If there's not one of those relevant or applicable, you would then fall back to the National Employment Standards. You cannot ever contract out of your obligations that are stipulated in the award or that are stipulated by the National Employment Standards. So what I mean by that is if the award or the National Employment Standards stipulate that you have to have 4 weeks of annual leave per year, you cannot contract out of making anything less than 4 weeks of annual leave per year. So it's always good to remember that you are governed by certain levels of industrial instruments or laws. So it's always good to bear that in mind. So the big question is, and I'm sure many of you know, what industrial instrument does actually apply to me? There are many awards, as I said before, that are in the stratosphere of fair work, but usually physiotherapists who practice in a private practice are covered by the Health Professionals and Support Services Award. There may be other areas of the business that may have different awards. There may even be employees within your business that have different award application. So it's good to know roughly where you sit in the awards and what classifications. So you're genuinely governed by your industry and what you do in that industry. It's always really good that you understand what industrial instrument applies, because you will be governed by that. Awards really do intricately lay out things like your obligations around breaks, payment rates, penalty rates, allowances, ordinary hours, overtime application, and these can vary between different awards. So it is really good to understand what award does cover your business and your employees. Now, there are different employment types and classifications. So let's look at the employment types first of all. So you have permanent employees, and that covers your full-time employees and your part-time employees. Now, this type of employment relationship is usually typical of people working regular hours. In the case of full-time, it's someone who works an average of 38 hours a week. If it's a part-time employee, it is less than 38 hours per week. And both full-time and part-time employees, as permanent employees, will accrue paid leave benefits, so paid annual leave and paid sick leave entitlements. Alternatively, you have casual employees who are treated a little differently to permanent employees. There's slightly different rules in place. A job offer of a casual nature does not include a firm advance commitment to ongoing work. The employee will accept the offer knowing that there is no firm advance commitment of regular hours. So that would indicate that they would have a varied work roster. They can decline shifts, and as an employer, you can alter the shifts each week. There is a casual loading of 25% on top of the ordinary hourly rate, and this is to compensate for those paid leave entitlements that permanent employees are eligible for. As a casual employee, you also have the, I suppose, the right to request casual conversion. Now, there are some changes coming up towards the end of the year in regards to casuals, and we'll sort of touch on those briefly at the end. But please note that there are some changes in the definition and the casual conversion clauses. So the other person, I didn't mean to forget them on the bottom there, but the other type of I hasten to say employee because they are not technically employee, but another person who can work for your business is a contractor. Now, contractors are slightly different again. That is a commercial agreement between businesses. So it's not technically employment, not technically our area of expertise, so I'm not going to talk about it too much. But there are some indications of what a contractor would look like. So they will usually work for other people. They work for the goodwill of their own business. They may even have a separate place of work. They may advertise their services to others. They may use their own equipment. They'll pay their own work-related expenses, and they would likely have an ABN and could even be registered for GST. So it really is a commercial agreement. If you do have any questions about contractor status, we always recommend Tanya White at Cross the T, and she'd be able to provide you with some guidance for contractors. There are some differences between contractors and employees. Obviously, I've mentioned some of those. And again, there may even be changes afoot in the contractor space towards the end of the year. But back to employees and employment types and classifications. So there are two streams in the Health Professionals Award. So you have the practitioner stream. Now this will cover, in your instance, physiotherapists. And that is classified by looking at the person's qualifications. So whether they, for example, have a bachelor's, a master's, or a PhD qualification. It will also take into account how much experience they've had in the field. So when we're looking at how to classify and we're looking through the levels, we're looking at qualifications and experience initially, and then we look at what type of role and responsibilities they have. So you will find that there are 4 levels of classifications with practitioners, so 1 to 4. And we generally look at level 1 being starting new grads, entry-level positions. Levels 2 is where people really start to get their footing. They start to become a little bit more independent. Level 3 is where they're probably mid-career. They're quite capable to do complex tasks by themselves. They may even start to be supervising or mentoring others, or they may even be in a leadership role. And level 4 is generally what we would look at when we're classifying people who have real input into the business. So we're looking at business directors, for want of a better word, general managers, or clinical managers. They're people that really are involved with the running of the business. Then the second stream is the support staff stream. So this is where your maybe administration team or your reception team would be classified. So we're looking at admin, reception, practice managers. We also do look at usually AHAs being classified in that space as well. Now, the way you classify support staff is fairly similar. Qualifications may be relevant. Experience may also be relevant, but support staff also hinges probably more so on what the job responsibilities are. So if you do have, let's say, an admin team, and you have a very run-of-the-mill admin position, which is very process-driven, there's lots of examples of how you make a booking, cancel a booking, send emails out, process payments, etc. You're probably looking at sort of that mid-range of a level 3, whereas if you're looking at a practice manager type role, you could be looking at a level 7 or higher. Again, that's general information. We are usually guided by what the position responsibilities are. And of course, you're more than welcome to go and have a look at the award to define what that is. Now, sometimes they can be quite vague and a little bit open to interpretation. But you'll see here on the screen that Schedule A is where the classification definitions are. It starts with the support services definitions. So you'll see there on the screen, you have level 1, which is entry level. So this is for someone that has less than 3 months work experience in the industry and performs very basic duties. You'll then see that level 2 is capable of prioritizing work within established routines, methods and procedures. And that actually is a level that is for between 3 months and 12 months. Those are the only 2 that are necessarily defined by period in terms of time for that level. Now, when we look at the classifications, there is something that's quite important within the Health Professionals Award, and that is the progression through the classification levels. So all classifications for practitioners should progress through to the next pay point of each relevant level in each year. So if they are working full-time, 38 hours a week, they would progress through to the next pay point automatically at every anniversary. So every year anniversary, they would progress to the next level, the next pay point. If they are working part-time, they need to reach a minimum of 1,824 hours before they can move through to that next pay point. Now, progression through to the next level, so moving from level 1 to level 2, 2 to 3, or 3 to 4, is also based on the annual hours. So either 38 hours per week, or which is 1,976 hours per year, or part-time 1,824. So it's also based on working those annual hours, but it does also depend on the responsibilities of the position. So if you are looking at someone that's progressing through levels, we should be seeing responsibilities that are shifting in line with their progression through their career. You may question whether someone moves from the next level if they're not undertaking responsibilities. Having said that, it would have to be a very, 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 I suppose, quite hearty reason as to why you wouldn't progress them through. Again, we cannot reiterate enough that if you have questions around classifications, their definitions, or how you implement that, please get in touch with us, because that's something that we do on a very, very regular basis. So let's talk a little bit about ordinary hours and rates of pay. So this rates of pay is obviously impacted by the classification level, but I am going to talk about the ordinary hours firstly. So the Health Professional Award does stipulate an ordinary span of hours that can be found under clause 13.2. There are two separate spans. So one is applicable to private medical, dental, pathology, physiotherapy, chiropractic, and osteopathic practices. That was a bit of a mouthful, so I'm very sorry. And those ordinary span of hours is 7:30 in the morning till 9 p.m. Monday through to Friday, and 8 a.m. till 4:30 on Saturdays. So those hours are specifically for those named practices. So obviously, being physiotherapists, those would be your ordinary span of hours. Now, sometimes I kind of get the impression that other allied health industries are a little bit jealous because their ordinary hours are slightly different. And theirs are Monday to Friday, 6 a.m. till 6 p.m. So you guys do have a larger span of hours. Now, this defines what their ordinary hours are in the week. So I'm going to talk a little bit about things like shift work and overtime, and that is what we are talking about in relation to ordinary hours. So those are the ordinary span of hours. If your practice is a multidisciplinary practice, then I would certainly get in touch with Fair Work, because we've had varying advice on this in the past. We used to look at the practice as a whole and what the most predominant profession was and go with that for the ordinary hours. But we have had recent advice as well that it's the profession that ordinary hours should apply to. So let's say you have a physiotherapist, but you also have a speech pathologist. You may have two different ordinary sets of hours. But that is certainly something I would get further advice upon if you need to. So the Health Professionals Award, and actually all the awards, have pay guides. So this is where you will essentially be able to source what the pay rates are for certain levels and classifications. So we're going to take a look here. So on the left-hand side there, you've got what the classification is. You'll see support services start first, and then it rolls into the health professionals or the practitioners classifications. So that's down the left-hand side there. Now you'll see up the top there that you have weekly pay, hourly pay, you have shift work Monday to Friday, Saturday and Sunday. So those hours or those columns are what are defined as the ordinary rates. So within those hours of 7:30 till 9. Please note that these figures do not include superannuation or leave loading. So if you're looking to say, okay, I'm going to bring on a new receptionist, I think they're going to be a support services level 3. I know, looking at this, that $25.88 is going to be the minimum hourly rate I can pay that person for them to work between the hours of Monday to Friday, 7:30 to 9 p.m. Now, if I look at the Saturday hours, you'll have a different rate of pay for the Saturday hours there, which I'm going to talk about shortly. So let's look at how we pay or when we apply overtime rates. We get a lot of questions around this and it can be really, really confusing. So the Health Professional Award states that overtime penalties apply if, and I'm going to group this together, if a permanent employee works in excess of their ordinary hours. So for a full-time employee, that would be anything over 38 hours. For a part-time employee, that would be anything over their contracted hours per week. For permanent employees, if they work over a shift in excess of 10 hours per day, then any time over that would also be considered as overtime. And for a part-time employee, it also encompasses if they work in excess of an average of 38 hours per week in a fortnight or 4-week period. So essentially a really good general rule of thumb is, are they working over their contracted hours or are they working a shift over 10 hours? Those are probably the two main ones to be very aware of. Now, for a casual, it is slightly different-ish. Still 10-hour shift rule applies and still the 38 hours maximum per week or 76 hours per fortnight. They also do have one more proviso where a casual employee is deprived of a break in between their overtime shifts. So everyone needs to have 10 hours off in between shifts. Overtime rates for permanent people is 150% of the minimum award rate for the first 2 hours and 200% thereafter. On Sundays, it's 200% and public holidays, it's 250%. Overtime rates are slightly different. It's from Monday to Saturday, it's 187.5% of the minimum hourly rate for the first 2 hours and 250% of the minimum hourly rate thereafter. Sundays and public holidays are again different. So it's very good to be aware of if you do have people that do longer shifts or that maybe work over their contracted hours, that overtime rates may start to apply. Now, the other thing that is also encompassed under the Health Professional Award is shift work penalties. Now, shift work has caused a lot of problems for us in the past, and we've delved into this many, many times. So there is technically 2 definitions of a shift worker in the Health Professionals Award. Now, in the first page, as you open the award, a shift worker essentially is an employee who has ordinary rostered hours of work that finish between 6 p.m. and 8 a.m. or commences between 6 p.m. and 6 a.m. Now, the other definition of a shift worker is featured in regards to the annual leave loading, and that would be the NES definition that you are working multiple Saturdays and Sundays in a year. So it's good to know that there are 2 separate ones. It doesn't usually affect many people in the allied health industry because not many practices we know have regular rostered hours on weekends or certainly Sundays. This definition of between 6 p.m. and 8 a.m. and 6 p.m. and 6 a.m. was defined in 2020, 1st of July. So it's really good to know that there are penalties involved if you do have an employee that, in a physiotherapist's example, would be working past 9:30 of an evening or prior to 7:30 in the morning. Now, there is a gap in the award, which we recently discovered, that shift work penalty is not actually stipulated, and that's between the hours of 6 a.m. and 7:30 a.m. So I know I'm just going to confuse everyone now, but if you have a physio that starts at 7 a.m., it's not defined technically as shift work. So if you do have someone that works prior to 7:30, but after 6 a.m., that would likely be an overtime rate and not a shift work rate. So just bear that in mind. And again, I'm happy to answer questions about that later if you need to. So if you do have someone that is working shift work penalties, it applies to the entire shift. So if you have someone that's working, let's say 1 p.m. to 10 p.m., that whole shift If it's a permanent employee, will be paid at 115% of the minimum hourly rate. And for casuals, it's 140% of the minimum hourly rate. Please note with casuals, they don't get the 25% casual loading on that one. Shift work doesn't apply to weekends or public holidays because they have their own set of penalty rates. So hopefully I haven't confused you all too much, because I've got some examples of overtime and shift work penalties. So we've used Jane, lovely Jane. She's a wonderful part-time physiotherapist, and her regular shifts include the following. So we have Monday 7 a.m. to 6 p.m, Wednesday 2 p.m. to 10 p.m, Fridays 8 a.m. to 2 p.m, and Saturdays 8 a.m. to 12 p.m. So I want you to have a quick moment. I think I created a poll for this, but I'm not keen enough to let rip with that one. So what I'm going to do is I'm going to get you to have a little guess, and you can tell me later whether you were correct or not. So the Monday 7 a.m. to 6 p.m. shift would be classed as overtime because it's worked 10 hours or more. So with overtime, it is literally the time that is past 10 hours. So if it's an 11-hour shift, you will pay the 10 hours as normal, and you would pay the 11th hour as an overtime rate. The Wednesday, 2 p.m. to 10 p.m, you've guessed it, that's a shift work. So that would have the shift work penalty applied for all hours, and that's because it's past 10 p.m. Friday, 8 a.m. to 2 p.m, is just your ordinary hourly rate. So there's no penalties on that one, which is fabulous. And the Saturday 8 a.m. to 12 p.m. would have Saturday penalty rates applied. So even though you do have ordinary hours or an ordinary span of hours on a Saturday, you still have Saturday penalty rates that apply to people who work those hours. So hope you got some of those right. We'll move through to allowances and remuneration. Just really quickly, there are some common allowances in the Health Professionals Award, and that can include things like first aid allowance. So if you do have someone that is named as a first aider in your business, there's a specific allowance for that. There's the uniform or laundry allowance, and then there's the very popular one that is kilometres travelled. And that actually is a higher rate in the award than what it is of the ATO. So again, just be mindful of those little quirks that you are governed by. Now, remuneration is a really specific and individual topic, and it can cover a vast amount of ground. For the purpose of me talking to you guys today, I'm going to take an overarching look at salary, benefits, retention, recruitment, etc. We often get quite a few questions about what do you think we should pay this person? And the answer is always in a very respectful way, how long's a piece of string? What we do and what we can only do when we're looking at things like benchmarking and better off overall tests is we look at the award in comparison to the award minimums that are stipulated in the Health Professionals Award. And of course, all the penalties and loadings that apply. What we cannot benchmark against, or we can, and we can give you guidance, but what we cannot look at is things like your location. Are you a metro location in comparison to a regional location? We don't necessarily look at what the market value is when we're looking at benchmarking or boots. We can certainly run that for you and say, okay, well, it looks like in your area, physios are being paid X at the moment. Many of you, if we've got business owners here tonight, you will know that possibly the back of COVID was a period where it was absolutely an employees market and salaries were going through the roof. It was going crazy. I'd like to think, and I've got my fingers crossed, that it started to calm a little bit now, but market value is still a huge element of how you decide what you pay employees, other than the award minimums. You guys can do that yourselves. I mean, obviously you can talk within your professional groups. Seek and Indeed also have benchmarking for pay guides or salaries. We have Robert Half, we have Hayes. there's a plethora of information that you can actually research out there. And of course, you have Seek and Indeed for advertising of other positions, if they're listing salaries out there as well. We cannot take into account what the current or trending incentives are within your industry. Again, coming off the back of COVID-19, we were seeing things like sign-on bonuses, which was probably quite limited to probably very professional environments. And all of a sudden it was everywhere. Again, hopefully that has calmed down a little bit. And the other thing that we cannot take into consideration is potentially other public awards or rates of pay. So comparing private practice to maybe a public hospital, for example, those things you as employers can take into account. But for us at Strawberry Seed, when you say, what should we pay someone? We can only look at what the award minimums stipulate for that person's hours, classification, etc. It's also really important to note, and I'm going to probably talk about this again in a moment, is that when you're looking at remuneration, quite often there can be bonus schemes or commissions. We always advise people that if you're going to pay bonuses or commissions, that they go on top of the base salary, keep them separate. And I'll talk more about that shortly. So we often get this question, what happens if I pay above award rates? And absolutely, that's great, fabulous if you are brilliant. The question we often get is, well, do I still need to pay all the allowances, or do I need to pay the overtime? You know, what do I need to do? I've got a person who's on $100,000. The award tells me they get $60,000. Is that okay? So you've heard me mention benchmarking and boots. So the boot is a better off overall test. So what we do in this situation is we say, okay, what is the employee's classification? Get that checked out. We then know what the minimum award rates are. We will then be asking you what hours they are working. We do this so that we know if there are any overtime rates or shift work rates, for example. We also need to know what loadings are included, etc., etc. So once we know what hours someone works, we know what the award minimum is. We can then take that figure and compare it to the figure that you are paying. Now, some people like to say, okay, well, we're 10% above award. That should be fine. And that's okay. I don't condone it because it's not a set and forget. If you are doing that, you need to continually monitor if hours are changing, if they're working additional overtime rates. If things change, if they progress through to the next pay point, their classification will go up, their pay rate will go up. So it needs to be continually monitored. It's also important to note that you can pay a higher rate of pay, but I would absolutely ensure that you have an offset clause in your contract. So a contractual offset clause stipulates that it may include, or the salary paid will include everything, including penalty rates, allowances, loadings, etc. So you absolutely must have that in the contract. If you don't, the employee could very well turn around and say, well, I didn't know that was included. And you have no recourse. So a better off overall test, when you are paying above award rates, that will provide us with what we call the outer limits of what is included in employees' hours in comparison to the award rates. So it's important to note that when we conduct a boot, a better off overall test, we always pay the hours that are worked. But if you are paying a higher rate of pay, it will be at that rate of pay. So, for example, if you have an employee that works 39 hours in 1 week instead of 38, and you pay that overtime rate, as long as it is encompassed in the outer limits, so essentially you've built in an extra hour of overtime, you can still pay at their ordinary hourly rate. But you're still paying 39 hours instead of 38 hours. I'll rephrase it. If that person is on $30 an hour, you would pay, and that's an above award rate, you would pay the $39 at the $30 per hour. If you didn't have an extra hour built in, you would have to pay the 38 hours at $30 and the last hour at the overtime rate. So like I say, it's not always as simple as set and forget. Don't rest on your laurels if you are paying above award rates. Make sure you know what is included in that salary. Now, I'm just going to show you really quickly a very, very basic case study. This is not technically how we do the boots. We do have a slightly more exaggerated Excel spreadsheet that's delightful. But just for simplicity's sake, I've used this format. So you'll see the top two lines there in green. That is an employee that works 38 hours a week, and they work all of their hours within the span of 7:30 till 9, Monday to Friday. So that is literally Monday to Friday, 9 till 5. You'll see there that it's $1,186.74 per week. That equates to just over $61,700 per annum. Now, if I look at the same employee who happens to do different hours, and I've based this on level 1 pay point 4 with an inclusive rate of leave loading. So I've used $31.23 per hour. So if I look at the blue section, I can see there that that person works 22 ordinary hours. So that's the rate of $31.23. I also know that they do 8 hours of shift work in 1 week. So that would get paid at the rate of $35.44. And I also know that they do 8 hours on a Saturday at the rate of $46.85. So you'll see there that there is quite a difference, $158.64 to be precise, between the yearly rates. So even if you have someone on the same pay point doing the same job, if they are doing different hours, they need to be compensated differently. So in that instance, you might pay the person in blue $70,000 per annum. You might pay the person in green $62,000 per annum to make sure that they are better off overall. More than happy to take questions about that later. It can be a very complex discussion about better off overall. Now, I said I would come back to it, commissions and bonuses. If you are going to put in place a bonus structure or an incentive structure, we always recommend to have it separate from the employment contract. You can certainly stipulate in the contract that they might have access to a bonus structure, but have a separate agreement about the bonuses. Now, the reason we would suggest that is because the bonus structure is usually above and beyond the base salary or the minimum award salary. So it's something that you are not legally obligated to provide. So if you have it in a separate agreement, you can make changes to that incentive structure or bonus structure. So you can have specific periods, you can have specific pay rates, you can have different KPIs for different pay periods, etc. That way, if you make a change, you do not have to reissue the employment contract. Now, the problem with reissuing an employment contract is that you need the employee's consent to do so. So that is why we would say keep bonuses separate. It is a lot easier. When you keep that separate, you need to know what the eligibility criteria is to actually gain the bonus, what the rate of bonus will be, when it will be paid. So is it paid every fortnight? Is it paid every 6 months or 12 months? And does that bonus include superannuation payments? Now, commissions can be structured a little bit differently, and my mind always kind of defaults to real estate when we're talking about commissions. If you're looking at the traditional commission structure, that probably should be contractually stipulated because you are paying award minimums, or you'd be paying a base salary, and then you'd be technically deducting that from the commissions. So that probably needs to be contractually bound. What is important to note about when we look at bonuses, commissions, incentives, etc., you always need to meet the award minimums for base salary. So they can never fall below that, because then you're at risk of underpayments. And that's why we always, again, suggest that we keep them separate. Keep it separate so that you can say, here's the person's salary, we have met our obligations here, and this is the bonus, and that's on top. Common salary mistakes. I don't like to say it, but I'm going to. Sometimes we do accidentally pay people incorrectly. I'm going to talk a little bit about the new wage theft things that have come in place, but we're talking about when we accidentally pay people incorrectly. Common reasons for that is that incorrect classification. That can be at the start of employment, or it can be along the employee's life cycle, because classifications will change and employees should progress through the classifications. And if you're not keeping up to date with that, again, you may be at risk of underpayment. Another common mistake is when people change days or hours, and they might go from ordinary hours to maybe shift work, or changing a Monday to a Saturday, for example. That may very well have an impact on their salary. And also, the happy news that we've got coming up 1st of July is that the minimum wage increases. And that happens at the beginning of every financial year. So again, 1st of July, we'll probably expect to hear the announcement of what percentage it will be in the next crystal ball time, in the next few weeks. And that will apply from the first full pay period after 1st of July. So those are some of the common areas where people do actually slip up when they're looking at paying their employees. I've done myself a few back pay calculations in the last few years, and many of them do tend to miss classification progressions, and some have even missed minimum award rate changes. So again, it's not set and forget. We do need to be regularly reconciling with our salaries and our employees. It's not usually done maliciously. And if you do spot a mistake, it's really positive to be proactive about that. If you realize you've made a mistake and you admit to it, and rectify any errors as soon as possible, then hopefully there's going to be no repercussions from that. The Fair Work website has a pay calculator, the PACT. You are absolutely free to use that. You can go in and you can select your person's hours, rates, levels, etc., and that will help you establish what the minimum pay rates will be. Okay, now I keep saying it and I'm really sorry to harp on, but I think it's a good place and forum to actually be able to just chat through what some of the recent industrial relations updates are. Now, as a business owner, you do have an obligation to provide an up-to-date and safe workplace for all your employees. So it is really important that you make sure that you are maintaining and updating and reviewing policies and procedures. And even if you can possibly have training within the workplace with your team members, especially when it comes to things like workplace health and safety. So it's very beneficial to be proactive about these things. And although there can be a lot of changes, please lean into resources such as Strawberry Seed, Fair Work, places like Victorian, I call it Becky, and of course the name's going to elude me, but Business Victoria and Business States, Queensland Business New South Wales, they all have areas that they can provide advice. So lean into those if you have any questions. So some of the recent IR legislation changes that have come into effect. I did mention before industrial manslaughter laws. Oh, no, I didn't. I talked about wage theft, sorry. So industrial manslaughter laws have now come into effect, which allow for both companies and individuals to be charged in relation to conduct that is negligent and causes death of another person. We have positive duty that has been implemented for all businesses and its employees, and that is in relation to sexual harassment in the workplace. And that essentially means, again, being proactive. So taking steps within your business to ensure that it is safe and to ensure that sexual harassment or hostile work environments or sex-based harassments aren't occurring. We have the criminalisation of wage theft. Now that is essentially a law that distinguishes between intentional underpayments. So again, it's probably not something to be too worried about unless you know you are intentionally underpaying someone. As I mentioned before, we all have errors at some point or another. Sometimes that occurs in payroll. As soon as you're aware of it, resolve it as quickly as possible. We also have psychosocial risks and hazards that have come to the forefront. So that is essentially an area that's looking after employees' mental health and well-being, as well as obviously the OH&S obligations that we already have. Prohibiting pay secrecy. Historically, we had a clause in our contracts and in our documents that said employees cannot discuss their remuneration or their salary with other employees. Unfortunately, that's now illegal. If you have it in existing contracts, that's okay, but it's not to be enforced. And if you have it in new contracts now, that is where you could potentially be fined. So if you do have any pay secrecy clauses in your new contracts, you need to remove those. We had a change in family and domestic violence leave entitlements. It went from 5 days unpaid to 10 days paid for all employees, including casuals. There have been some changes around fixed term contracts. Essentially, that's limiting it to one renewal, and you can only have up to a 2-year fixed term contract. There are some provisos and exclusions from that. But again, if you use fixed term contracts frequently, touch base with someone like Strawberry Seed and we can help guide you through the new changes. Coming up towards the end of the year, we have changes in the definition of a casual worker. Now, I did jot down what those were going to be. Again, it's still stipulating that there's no ongoing firm advance commitment. There will also be a change in the casual conversion eligibility. There will be a change in the definition of employment. There are going to be other elements for independent contractors. It won't just be based on the contract. It will be based on day-to-day interactions and what they look like. And we also have that wonderful right to disconnect, which again is an element where it makes it, it's about reasonable contact outside of work and whether an employee has the right to not respond. It doesn't mean that employees won't be able to make communications outside of work hours, but it will bring into question whether an employee has the right to not respond. So that'll be an interesting one that will come to the forefront. For small businesses, that won't apply until actually next year. So you may have some time up your sleeve before that one's implemented. Now, I did talk about it. Documentation. We say it all day, every day. Write everything down. Look, the nature of small businesses or medium-sized businesses can be quite often that many communications we have are verbal. As business owners, you are considered as having the position of power in an employee-employer relationship, which usually means that the onus of proof is on you to prove that you followed fair and due processes in all aspects. So especially when we're looking at performance management or terminations. But it also does come into play with things like pay queries. You have to be able to prove what that person has worked and what you've paid that person along the way. So having a paper trail is essential. It protects yourself and the business, and it does also protect third parties or your employees. And again, we have a lot of cases that we look at in terms of unfair protections, unfair dismissal claims or general protections claims, where we've gone in and been able to say, well, actually, no, this is what happened and here's the documentation to prove that. So what does it include? What do we need to document? Employment conditions. So if someone changes their hours or if they get a pay rise, those things need to be put in writing. Discussions about performance issues, even if it's an informal discussion, even if it's just a passing in the corridor or in a one-to-one, if you've mentioned something like that verbally, it's great to follow it up with an email. Warnings, absolutely, and performance management processes, and things like leave. You know, if someone's requested leave, can you just pop it in writing to me? How to document that can be included in things like official documentation, so contracts, policies, procedures, sign-offs, agreements, and things like that. Email correspondence is absolutely legitimate and is often the way we do correspond these days. That's great because it's time-stamped. So it's always a really, really good way to follow up with documentation. Text messages, we wouldn't necessarily always say, you know, communicate you've got a problem with someone via a text message, but if it is following up on something simple like, yes, okay, please take leave, or something along those lines, and that is a usual correspondence method, that's fine. You have things like instant messaging as well, so Slack channels, for example. They may also very well be written documentation. You can also have file notes as well. So if you do have a conversation and you're jotting down some handwritten notes, they can obviously be your file notes if you need them to be. So key takeaways from this evening. It absolutely is your responsibility to know which industrial instrument or award applies to you. And whilst I confess most awards are not great nighttime reading unless you want to go to sleep, but it is good to know what the nitty-gritty parts of that instrument are. You know, how does that work on a day-to-day basis? You know, breaks, hours, rosters, etc., how that works on a day-to-day level for you and your business. And do try and wrap your head around the application of things like penalty rates, loadings, and allowances that may apply to your industry. Again, if you don't know, ask. We can certainly help with that. You'll also have things like minimum shift hours, world's your oyster. There's so many things in the awards that are covered. So if you haven't yet, it's always good to go and have a good look through that and see if you can make any sense of it all. Make sure you do protect your employees and yourself and your business with relevant updates to IR legislation, especially now, especially in the space of sexual harassment policies, training. Educate everyone as much as you can. And there it is again, don't discount the importance of documentation. Write everything down, get it in correspondence. Make sure you do review your contracts, your policies, your salaries on a regular basis to make sure you are compliant. And whether that's through HR companies such as us, Strawberry Seed, or whether it is some other avenue, please make sure you are trying to do your due diligence. I can't get it out on a Wednesday night. I do apologize. But do make sure you're being proactive in that space. Just as a final sort of hurrah, you can look at our previous webinars on our website. And we also do have some upcoming training. We have mental health first aid, and we also have leadership training, which again is on the Strawberry Seed website. Now, questions. Now, please bear with me, and I'm going to just go to the Q&A section. Okay, so we've got a few questions here. So for full-time employees, do they automatically progress annually if they haven't worked for a full year? E.g., they've taken an extended period of leave. The answer to that is no. So we are looking at experience in the chosen profession. So if you have a physio that disappears wonderfully for a whole 12 months to tour the world, not that I'm jealous by any stretch of the imagination, but that would not count as a year of experience. The same would apply if that person took a year off and worked in a completely different profession. So if they were not practicing as a physio, let's say they went off and, I don't know, worked in an office for 12 months, that would not be counted, and it would not be a year of progression. So hopefully that helps answer that question. When determining classification levels for new employees, do we base their level on our job description and the role, or their previous experience and years in the workforce? E.g., a new team member has been a team leader at another workplace, although is joining our clinic as a therapist without team leader responsibilities. Great question. And it's one that we do rely a little bit on the employer at the time. I would suggest you will always include what the qualification is and what the experience is. That has to be your minimum. Then if you're looking at a role that doesn't necessarily have leadership qualities, then you may, I mean, look, if it's the difference between a level 1 pay point 2 and pay point 3, you'd probably err on the side of caution and go the higher pay point. If you're looking at it being different between levels, that's when you're really going to have to use a little bit of your own judgment and say, well, look, I know this person has loads of experience, and given that experience, they're probably going to bring quite a bit to this role, even though it's not necessarily official. I may choose to pick the classification that's the most accurate for their qualification, experience, and the responsibilities. So that might be a level 1 pay point 6, for example. But to recognize that they have been a team leader and they might bring all these other qualities, I might like to pay them a higher rate of pay. Talk to, us in that instance, because it can be very hard to define the classifications. But the 3 things are the qualification, the experience, and what they are doing in the job, and what their responsibilities are. What they're doing in the job is kind of that last port of call, that last checkpoint. So I would certainly suggest that you talk that through, look at the classifications, and if in doubt, err on the side of caution of the employee and choose the higher classification level. Hopefully, if you do that, then obviously you're reducing any risk along the way. And final question, potentially, what's the easiest way to track or monitor award classifications? Should we use our bookkeeping payroll system? Again, really great question, because a lot of people slip through the cracks, especially part-time employees. We're not necessarily monitoring that 1,824 hours that they're working. At Strawberry Seed, we do a benchmarking once a year. So we will support our clients once a year, and obviously it aligns with the 1st of July pay changes. You can always backdate payments. So if you realize you've missed someone's anniversary, you can always backdate it. If Xero has the function for that, absolutely use Xero. Otherwise, you can possibly have calendar notes. Maybe it's something as simple as having something on the wall that has people's anniversaries. You may choose an Excel spreadsheet, especially if you're looking at part-time employees and calculating their 1,824 hours. Otherwise, like I say, you do it once a year or you do it twice a year. And if you've missed anyone, you can backdate them. It is something that's important, but it has to also work in with how you operate as a business. It doesn't need to be time consuming. So sometimes, even like you say, when you onboard someone, you put a calendar note in to say that's their anniversary. And like I say, it might take a little bit more work with part-time people to work out when they surpass those hours. But it doesn't have to be complex. Choose what suits yourself and the business best to try and keep track of that. Those progressions. Okay, is there any more questions or queries? If anyone wants to pop anything in the chat function, you're more than welcome to. I'll give you just a brief moment to think if there is anything you'd like to discuss further. And whilst you're doing that, I'll just give you all our socials. So we obviously are on Facebook, LinkedIn, and Instagram. Our Instagram is I love it. Every time Carly, our director, posts something, I'm like, yeah, I'm hearing that. We have a very dry view of what HR is and what we endure. So it's always good for a giggle, if anything else. But if nobody has anything else, thank you all very much for joining tonight. I'm more than happy to stay on if there is anything else further you'd like to talk about. And if you do have any questions, queries, follow up, or if you'd like to talk to us about any packages or any assistance with your HR, please get in touch with us through any of the channels, Clint Mastery or ESSA, or through the website. Please don't hesitate. We look forward to helping you in the future. I hope you all have a lovely evening, and we look forward to working with you again soon. Have a very good night. Thanks, guys. Bye-bye.